A U.S. court decides Iraqis allegedly tortured at the infamous Abu Ghraib prison cannot sue the defense contractor who employed their interrogators. What are the wider implications of the ruling now that military contractors play such a central role in U.S. operations abroad? You're watching Inside Story Americas from Washington. Hello, I'm Shihab Rattansi. These four men were held at Abu Ghraib between 2003 and 2004. During that time, they say they were stripped naked, electrocuted, beaten, choked, and threatened with death. They were all released without charge. They came to the U.S. to seek accountability for the U.S. military contractor CACI, whose employees conducted interrogations and other tasks at the prison. But this week, a judge in Virginia threw out their case, saying that the Iraqis cannot sue the contractor in the U.S. because the, quote, alleged conduct giving rise to their claims occurred exclusively on foreign soil, end quote. Judge Gerald Bruce Lee cited a recent Supreme Court ruling to support his decision. In that case, a group of Nigerians sued Royal Dutch Shell for aiding their government in committing human rights abuses. In April, the Supreme Court ruled that since the foreign oil company acted overseas, it cannot be sued in the U.S. So what precedent has been set for holding U.S. corporations accountable for crimes committed overseas? And we're joined from Dallas, Texas by Shereef Akeel. He's one of the lead lawyers on the Abu Ghraib case against CACI. And here in the studio, we have Marco Simons, the legal director for EarthRights International. We did ask CACI to join our discussion, but they did not respond. Shereef Akeel, then, first of all, let's begin with what exactly happened to your clients at Abu Ghraib. How were they treated?
Well, our clients were subjected to extreme brutality, the kinds of acts that are unspeakable, which included brutal assaults, forced nudity, diet manipulation, subjected to extreme climate and environmental manipulation, the kind that are just unspeakable as to exactly what they were subjected to.
And who was carrying out this abuse?
Well, the evidence has shown that the military police were participants in this, but they were taking orders from higher-ups, and one of those were contractors that were employed by the government that participated in the abuses in Abu Ghraib. One of them was CACI.
So how then, or at least under what jurisdiction, have you brought a case in the U.S., though, against CACI in the U.S. for crimes committed in Iraq?
Well, our founding fathers envisioned that all humans are deserving of humane treatment, and they enacted a law called the Alien Tort Claim Act, which allows for cases like this to be brought in the courts of the United States for crimes against humanity or war crimes of the like that we witnessed or we saw, unfortunately, in Abu Ghraib.
Marco Simons, this is probably a good moment just to step back a little bit then and talk a bit more about the Alien Tort Statute of 1789, the Founding Fathers. What was the intent and purpose, though, of the Act?
We have to remember that in 1789, the United States was a new nation, a young nation, and it was very concerned with its stature in the world. And so the Alien Tort Statute was passed in part to affirm the commitment of the new nation to following international law. The concern of the Congress, this is the first Congress as part of the first Judiciary Act, which set up the court system, so one of their very first acts, they were concerned that the federal government didn't have any ability to enforce international law, that only the states and state courts had any jurisdiction over violations of international law. And so the purpose of the Alien Tort Statute was to take cases where there were serious violations of international law and to say this is a responsibility of the federal government, of the federal courts, and we are going to provide a remedy in the U.S. courts for these violations.
But it wasn't really much used, though, till pretty late, though, till pretty recently, rather, like 1979 or so.
people forgot about it for nearly 200 years. And during this time, the scope of international law evolved. And so, whereas in 1789, international law encompassed things like piracy and assaults on ambassadors, by the 1970s, 1980s, it was firmly established in international law that basic human rights were protected, that governments could not abuse their citizens in horrific ways, that things that Shereef was mentioning, crimes against humanity, war crimes, genocide, that these were all grave violations of international law.
And that they were standing in U.S. courts.
And that the U.S. courts could hear these cases, yes. And the courts consistently ruled that these severe abuses of human rights could be heard in U.S. courts.
What sort of examples? I mean, how effective has this been in the past?
It's in some ways, it's been very effective in sending the message that if you come to the United States, if you live in the United States, if you do business in the United States, that you are going to be held responsible for your conduct anywhere in the world. It's not the United States acting as the world's policeman in the sense that we're going and picking people out of foreign countries. The court still has to have jurisdiction over the defendant. They have to have some connection to the defendant. In this case, a U.S. corporation. Right.
But say, for example, let's go straight then to the Kerbel Royal Dutch Petroleum. The reason why the Nigerian plaintiffs thought they had a case there was this principle that, look, if Shell is going to do business in the U.S., then you've got to play by our rules no matter where you do business, I suppose.
That's right. Normally, the ordinary rule is that anybody doing business here is subject to the jurisdiction of our courts. And the Supreme Court essentially decided to change that rule when it comes to grave human rights abuses.
Yeah, and we have a portion of the majority opinion of, this is written by Chief Justice John Roberts, quote, "On these facts, all the relevant conduct took place outside the United States, and even where the claims touch and concern the territory of the United States, they must do so with sufficient force to displace the presumption against extraterritorial application. Corporations are often present in many countries, and it would reach too far to say that mere corporate presence suffices. If Congress were to determine otherwise, a statute more specific than the ATS would be required." So, and just a quick reminder there, that the specific allegation was that Shell was helping the Nigerian government commit human rights abuses in areas where they were drilling, basically, to stop land disputes and things like that, right? So did that judgment then entirely shut down the Alien Tort Statute there?
Well, nobody thought that it did because of this language suggesting that in the Wright case, where there was a sufficient connection to the United States, that even though injuries may have happened outside the United States, courts could still hear the case.
Well, I mean, this specific ruling there, was it because Shell wasn't a U.S. company? No, I mean, that doesn't then make sense because Shell does business in the U.S. I mean, was it clear how that...
They didn't say exactly why, but the Supreme Court did what they often do, which is they didn't announce a broad rule. Right. They said on the specific facts of this case, there isn't enough connection. We're not going to say what is enough. We're not going to give you a roadmap for what case would be permitted to proceed. But we're going to say that in this case, where it's a foreign corporation, where the acts occurred outside the United States, where it's a multinational that's present in many countries, that's not enough to bring a case in U.S. courts.
All right, but there has to be some very clear connection to the U.S. there.
Something more than in the Kerbel case.
All right, so Shereef, let's now bring it up to date then with the case, the case that you brought. And this was the judgment of a district court judge in Alexandria, drawing on the Supreme Court decision of Kerbel. Here's a portion of his ruling. Quote, "Plaintiffs alleged that torture and war crimes occurred during their detention in Abu Ghraib. Plaintiffs' ATS, Alien Tort Statute claims, do not allege that any violations occurred in the United States or any of its territories. Therefore, on these facts, the court holds that Kerbel's bar against extraterritorial application of the ATS governs." Shereef Akeel, is that, in your opinion, an appropriate reading, then, of the Supreme Court judgment of how the Alien Tort Statute applied to Shell in Nigeria and and the implications of that?
We're obviously very disappointed with the ruling, and we plan to appeal. If any case has a direct relationship to the United States with sufficient force and touch and concern. It is this case. You have our clients who were subjected to the most unspeakable crimes in American-run prison and under an American-led operation where the leader in Iraq at that time, Paul Bremer, was reporting to Secretary of Defense, then Secretary of Defense Rumsfeld, who was reporting to President Bush. You know, and one of the things that's striking here is especially that's important to keep in mind is that after the revelation of the Abu Ghraib abuse, we made a promise, and Secretary of Defense testified, Rumsfeld testified in Congress that we need to seek a remedy to ensure that these victims are justly compensated. We've had military police court-martialed for their participation, and now we have the contractors who are likewise being hailed into court to face the claims that they committed, and this ruling runs contrary to the nation's efforts to remedy the very wrongs that have tarnished our nation's image. And I don't think that is the consequence that the Supreme Court had in mind when they wrote the Cobalt decision. There is no question that this case is clearly distinctive from the Cobalt because you have the actors, the defendant here is an American company, and you have the victims who were all tortured and subjected under a prison led by American personnel under an American operation. Who were participants in the. So it's a clear distinction here, and we're obviously very disappointed with the ruling.
Marco Simons, I mean, clearly then the judge in Alexandria in Virginia here mentioned extraterritoriality. But is that relevant when a country is under U.S. occupation, when Paul Bremer is basically the de facto ruler of the country? Is that necessarily then not part of the, is that not part of the U.S. then? Is that extraterritorial?
It shouldn't be considered extraterritorial, and the judge did something very perverse here, which is what the judge said was, on the one hand, Iraq was not considered part of U.S. territory for purposes of applying the Kiobel case, and therefore it was outside the United States, and those claims cannot go forward. On the other hand, the judge then said the only law that applied in Iraq at the time were the regulations of the Coalition Provisional Authority. And those regulations said, according to the judge, that CACI couldn't be sued under Iraqi law or Virginia law because it's headquartered in Virginia or any other law.
Right.
And therefore, at the same time as he said it's not U.S. territory, he also credited the U.S. written regulations as the only legal authority in Iraq at the time. So the judge essentially said no law at all applies to this territory. The U.S. wrote regulations that are the only law that applies, and the U.S. law that should otherwise apply doesn't apply.
Because it's not part of the U.S., it's extraterritorial. All right, as we try and work out that reasoning. Shereef, another issue was raised as to whether military contractors are technically involved in combat operations, so therefore they're protected under a principle of eliminating tort, of eliminating civil wrongdoing cases on a battlefield. Did that seem persuasive to you, that military contractors were somehow protected because this was a battlefield and you don't have, normal laws don't apply during war?
It is undisputed, and it's well documented that CACI was in a non-combat role, and they did not enjoy the immunities or privileges that they're trying to assert that military personnel would have. There was a contract between the United States and CACI to provide interrogation work within the laws, the laws of international laws. So if they transgressed or crossed that line, they would be liable.
Right.
So that issue of combat is a red herring.
I mean, the CACI, is its role, does it have a place in the chain of military command then? Is that what the judge seemed to think? I mean, it doesn't, does it, or does it?
The judge really in this ruling did not address that. He was focused on the Coble decision.
Right.
And the immunity, the immunity defenses raised by CACI were not at issue for that ruling.
Yeah, and I guess we always have to underline the fact that this was not a ruling on whether CACI did anything wrong. It was simply whether they were standing in this court to prosecute, or at least to find out whether they did anything wrong. Marco, go ahead.
Right. There's one thing I'd like to also mention,
Yes.
and that's why we were surprised, again, regarding the consequences, that the court said if a decision is rendered in favor of CACI, will it address the Supreme Court's concern that now we're going to be creating a safe haven for corporations to engage in atrocities overseas and then to seek cover in the United States.
Right.
And if you look at the decision here, with this case being tossed out, now what we have here is a corporation. There's an allegation of corporation committing the most unspeakable crimes, and they're here right now enjoying the profits, and they have not been hailed into court for the accountability for the claims that have been raised against them.
Yeah, I mean, Marco, if there is the CACI says, look, no, we're just part of the same rules as the military as part of combat operations. At least the military, however inadequate it was, did have some form of accountability for at least 11 soldiers, convicted of minor offences. At least they did have some form of accountability. But did the judge not address the fact, though, that as a result of this ruling, the military contractors don't even have that. They've got no oversight, no accountability, no process of redress for those who claim human rights abuses.
Yeah, the judge seemed almost willfully unaware of the consequence of his decision, that he was essentially saying no law applies to the operations of this military contractor in Iraq, that there is no system of accountability whatsoever that could rein in their abuses, which is extremely disturbing given the United States' stated commitment to protecting human rights and the importance of the image of protecting human rights.
And also the fact that increasingly military contractors are doing more and more work off the military. Often companies that, as we now know, the State Department and other departments in the government know full well have a pretty terrible record on human rights and discipline and things like that. I mean, what are the wider implications then for all the military contractors who are now currently working for the U.S. overseas?
Well, it's not just military contractors, it's U.S. corporations generally, because the United States has a responsibility not only to police the operations of its own contractors, but of its corporations generally. And under this ruling, it seems that any U.S. corporation could go around the world and commit any human rights abuse that they see fit, that would benefit their bottom line. And the U.S. courts would not have competence to hear claims against them for genocide, for crimes against humanity, for the worst abuses in modern society, even if it's a U.S. corporation going in and committing these crimes. And that's really, contrary to the intent of the Alien Tort Statute.
So, I mean, I know you have lots of litigation that has been underway for years there against Chiquita Bananas, say, or various other U.S. corporations. I mean, has this effectively shut down your operations then? Or?
It hasn't yet, and we don't believe that this judge's interpretation of the law is going to be adopted more generally. We think that it is an incorrect interpretation of the case. But for example, in the Chiquita case, Chiquita is very obviously a U.S. corporation headquartered here. The U.S. is its main market. It's all about the United States. For years, it was paying a Colombian terrorist paramilitary organization that was going and assassinating labor leaders and killing various other people, leftists in Colombian society, committing thousands of murders and torturing people left and right. And Chiquita was prosecuted by the U.S. government for its payments to this organization, which were a crime under U.S. law. So you have a U.S. corporation committing a U.S. federal crime and funding a terrorist organization, and yet Chiquita is now arguing that this case doesn't have a sufficient connection to the United States in order to allow it to proceed in federal court.
But does that look like a strong case? I mean, I suppose at least in this case, I mean, there is all this. I don't know what the judge in Virginia seemed to think was a grey area in Iraq at Abu Ghraib at that particular time, whereas surely there's less of a grey area in the Chiquita case. Or...
Hopefully we won't have the problem where a judge will decide that no law applies here,
right,
because clearly Colombian law applies in Colombia, and so that particular problem, I hope, will not be replicated. But it is disturbing that that the judge in this case did say that it doesn't matter how much of a connection you have to the United States. The abuses happened outside the territory of the United States, therefore case closed, it cannot go forward. And if that ruling is adopted, it would be very damaging to the stature of the United States around the world.
So, Shereef, what does this mean then? So in the past, say, the US government would rely on countries with terrible human rights records to, torture people for the US government. But now what? The US government can set up, contractors, US contractors in another country, and as long as they're not caught by that country, they can torture away and never be prosecuted in the US. I mean, what are the wider implications here?
Well, that's obviously a consequence here. We have to practice what we preach, and when we are ruling in a manner that's adverse to the protection of human rights, that obviously it's another black eye to our country. What is important here also in the Coble Supreme Court decision is that the majority was concerned about invading the province of a sovereign or the will of a sovereign, and to also to undermine the executive decision of the executive branch, the decisions made by the executive branch. Again, in this case here, we don't have these concerns. We did not have a sovereign. If you recall, there was a ceremonial transfer of sovereignty from the coalition back to Iraq, and led by Bremer. And the executive branch, they assigned Bremer to lead. We had the Iraq judiciary, they were reporting to Bremer. The military was reporting to Bremer. So we didn't have the concerns of sovereignty as we had in Nigeria in the Coble matter. There is no question this case is ripe for a reversal, given the distinctive facts here. And it is needed for this country to get over the atrocities that was committed under its watch.
Marco, in the past, though, the Obama administration asked the Supreme Court to reject an appeal, a previous appeal by 250 prisoners at Abu Ghraib, to sue, who wanted to sue contractors. The Obama administration gave a brief saying, well, no, let's wait to see what the lower courts do first, before we allow them to sue. I mean, so do you think? I mean, the Obama administration hasn't been terribly keen, by the way, as we know, on holding people accountable for torture, and especially those in the past. We have to look ahead, as President Obama says. But do we expect any action? I mean, this is such a huge grey area on contractors now that has been opened up. Do we expect any action from the Obama administration to clarify this position, or at least try and clarify this position?
I hope that the Obama administration would take the position, a very pro-human rights position, that in this case, that it is appropriate for U.S. courts to hear this case. But it's hard to predict.
Is there the slightest bit of interest, though, perhaps, in holding contractors accountable at this point?
It's hard to predict. The U.S. government submitted a brief in the Kiobel case arguing that that case should not go forward.
Yeah.
Our Attorney General, Eric Holder, formerly represented Chiquita
right.
in defending against claims of the very claims I was talking about, of funding crimes against humanity. So it's difficult to predict what the administration will do in such a case. And I think the disturbing part about this, or one disturbing part about this, there are many, is not just the avoidance of accountability for torture, but also the administration's protection of corporations almost at all costs, yeah. Which has extended into the Supreme Court. The Supreme Court, I think it was significant that the Kiobel case was a case against a corporation and not against an individual torture, and there have been many of those, because corporations have been on a hot streak in the
right.
Supreme Court lately, and so
I think there was a headline in Bloomberg saying this has been a great year at the Supreme Court for corporations. Like
13 out of 16 cases supported by the U.S. Chamber of Commerce they got their result in those cases.
Shereef Akeel, as far as this case is concerned, then what is the next stage? What should we be looking out for in litigation?
Well, we're obviously going to be appealing this decision to seek reversal, so we can have the matter be sent back to trial, so our clients can have their day in court. That is our promise to them of our efforts to do what we can to vindicate the very wrongs that they were subjected to.
Shereef Akeel, thank you very much. And Marco Simons, thank you as well. And that's all from the team in Washington, D.C. for now.